Welcome to Mint Views. Today we discuss the case of an Air India pilot who has dragged the company, the airline that is, Air India, to the bankruptcy courts for insolvency. The National Company Law Tribunal, that's the body that looks after cases of insolvency under the Insolvency and Bankruptcy Code. Now, this pilot hasn't been paid for some time, and the dues owed to him run into the tune of around 1 crore. The Supreme Court has allowed him to actually file a plea at the National Company Law Tribunal to judge whether or not the company should be pushed into insolvency because they haven't paid this one pilot his dues. Now, on the face of it, it sounds absurd, but apparently this kind of thing is actually allowed. The question is, does this actually pose a big hurdle to Air India's disinvestment program? That's one question. The other question is whether the IBC, which was originally launched to actually clear up our problem of bad loans, things like that in the economy, is actually beginning to be a drag on the process by which we actually clean up the economy. That's what we have for debate today, so we shall kick off. Shrija, what do you think of what's happened here?
You're absolutely correct, Arish, when you say that this sort of filings, it basically undermines the law or the IBC when it was first instituted. The major motive of the law was resolution of the distressed assets, or for the cases to get resolved within the stipulated time period. And strikingly, there's data from June 2019 which shows around 34% of the 1292 cases have actually run beyond the stipulated time period, which tells you that the law is not working as it should be.
So we have had a case here where an operational creditor, an employee, is saying this company is insolvent because they haven't paid me my money. But that's not the original purpose of this law to begin with. It poses a lot of problems, doesn't it? Anand, what do you think?
Yeah, actually, but we have to look at the other side also. You're right that, this is becoming an impediment in the process of clearing up all the bad loans that have piled up. The law itself is becoming a hurdle. But the other side of this debate is, where do the employees go? And, the employees themselves right now, do they have a good redressal mechanism? The first stop for them is perhaps the labor commissioner. But these offices don't really function in the best possible manner. They also are afflicted by all the problems that our judicial system faces. So what do the employees do? Now we have an example over here in the case of SR Steel case, where even employees have been given or have been allowed to be categorized as operational creditors, so that their dues are not left behind. When a liquidation takes place, their interest should also be protected. That's what it was trying to do. So I think we need to look at the other side also.
Should they have the power to press for insolvency? That's the whole question. And surely there must be something else, some other way to resolve a problem like this. Srijay.
I agree with you, Arish, totally here. They should not have any powers to trigger insolvency, the employees themselves, because that actually amounts to trivializing the law itself. And if you look at it, if this will set a precedent for other employees as well, to kind of sue their companies or take them to the insolvency court. And especially in the case of Air India, imagine the government is planning to disinvest its stake in the company, and if such cases keep coming up, do you think that the government would be able to disinvest and meet its divestment target?
Yeah, it looks like, yes, you made a point that Air India, the disinvestment process seems to be in big trouble. This could just hold it back.
Yeah, but before I come to disinvestment, just one point I wanted to make on the comment that Srijay has made, that usually what happens is when you have similar cases filed by a group of interested parties, then these are classified as class action suits. Even in the US and in other countries also, examples are there that these are clubbed together and considered. So I don't think we should be too afraid about too many employees coming and filing cases against the companies, because I'm sure the right process would be to club them up and listen to them properly and either hear them out in the judiciary or send them to the appropriate authority to consider. Mm-hmm. And as far as disinvestment is concerned, you're right. Actually, Srijay is right that this is a little worrying, because there are still several hurdles that the government needs to overcome in going through the disinvestment of Air India. This is going to be a really long drawn process.
Yeah, the other problem is that when you go for insolvency in particular, it's a very harsh provision. They actually take over the company if they find there's a case for insolvency, in which case a resolution professional actually takes over the operations of the company. So a single pilot not being paid could potentially actually mean that Air India's management passes into the hands of a resolution professional. And there, it's not very clear whether this is the right forum for people who are disgruntled. So we have a lot of unresolved issues in this entire IBC process. All of them need to be sorted out because our courts, the NCLT courts, all of them seem to be clogged. We need to declog all of this, and we need to treat only real cases of insolvency, SR Steel being a prime example, with the kind of attention that the law should give it. Thank you.